This video contains AI-generated visual and audio representations used solely for educational and illustrative purposes. The United States Supreme Court justices depicted in this video are generated by artificial intelligence. Filming, recording, or broadcasting inside the Supreme Court, including oral arguments in the justices' private conferences, is not permitted. Accordingly, no real footage, audio, or recordings of the court or its deliberations are used. The arguments, questions, and opinions presented are paraphrased and condensed to accurately convey the general legal positions and reasoning expressed in the case while remaining brief and accessible. The attorneys for the petitioner and respondent are fictional, generic characters created to summarize and present shortened versions of the parties' arguments. Any conversations among the justices during conference are entirely hypothetical. These discussions are not transcripts or reenactments of actual deliberations, but are designed to help viewers understand the justices' commonly recognized jurisprudential approaches and viewpoints based on their publicly available writings and opinions. This video does not constitute legal advice and should not be relied upon as such. It is intended for educational and informational purposes only.
Hey, Jamie Carper here. Today's Supreme Court case answers a question that has absolutely ended relationships, roommate situations, and at least one Thanksgiving dinner. If two people live in the same house and the police ask to search, who gets to decide? The case is Georgia v. Randolph, 547 U.S. 1032006. Here are the facts, clean, quick, and extremely domestic. Police respond to a domestic dispute between Scott Randolph and his wife. At the house, Mrs. Randolph tells the officers that her husband uses cocaine. The officers ask for permission to search the home. Mrs. Randolph says, yes. Mr. Randolph, standing right there, says, no. The police search anyway, relying on the wife's consent, and they find cocaine. Randolph is charged. Now to the lower courts. The Georgia trial court suppressed the evidence, saying the search violated the Fourth Amendment. The Georgia Supreme Court affirmed, holding that when one occupant is present and expressly refuses consent, police cannot rely on another occupant's consent. The state of Georgia asked the U.S. Supreme Court to reverse. So here's the issue before the court. When police seek to search a shared residence and one occupant consents while another occupant who is physically present expressly refuses, does the consent override the refusal? In other words, is yes stronger than no when they both pay rent?
We'll hear argument this morning in Georgia v. Randolph.
Mr. Chief Justice, and may it please the court. This court's precedent allows police to rely on the voluntary consent of a co-occupant who possesses common authority over the premises.
So your position is that one occupant's consent is enough, even if the other occupant is standing there saying no?
Yes, Justice Scalia. Shared authority means shared risk. When you live with someone, you assume the risk that they may allow others, including the police, inside.
But here the refusing occupant is present and expressly objects. Doesn't that matter?
No, Justice Stevens. The consent of one with common authority should suffice. Otherwise, police investigations become hostage to the most uncooperative resident.
But what social understanding supports that? If two people are home and one says no, do guests usually enter anyway?
This is a law enforcement context, Justice Breyer, not a dinner party.
But Fourth Amendment rules often track social expectations.
The court should focus on administrability and precedent.
Mr. Chief Justice, and may it please the court. When a physically present co-occupant expressly refuses consent, the police may not search the home based on another occupant's consent.
What's the principle?
The principle is reasonable expectation of privacy grounded in social norms. No reasonable person would think a guest or the police may enter over the objection of someone who is standing at the door saying no.
So this is about common social understanding?
Exactly. The Fourth Amendment reflects ordinary expectations of privacy.
What about officer safety or domestic violence concerns?
Those may justify entry under other doctrines, exigent circumstances, but not consent alone.
Our consent search cases rest on social expectations. A co-occupant may invite a guest inside, but not over the objection of another present occupant.
This creates a new rule, one that complicates police work.
It's a narrow rule. It applies only when the refusing occupant is physically present and expressly objects.
The home has special constitutional status. If someone is at the door saying no, that refusal should carry weight.
And it aligns with everyday life. If two people are home and one objects, entry doesn't happen.
But why privilege the objector over the consenter?
We don't privilege either. We recognize that shared authority does not include the power to override a present co-occupant's refusal.
This limits police reliance on consent.
Only in a narrow circumstance and only in the home, where privacy is at its apex.
So, no means no if you're there to say it.
Justice Souter has the opinion of the court.
We hold that a warrantless search of a shared dwelling is unreasonable and invalid as to a physically present resident who expressly refuses consent, notwithstanding the consent of another resident. The Fourth Amendment does not permit entry in the face of such a refusal.
All right, here's the holding. When two people share a home and one is physically present and clearly says no, police may not rely on the other person's consent to search the home. That's Georgia versus Randolph. Why does this case matter? Because the Fourth Amendment is built on privacy expectations, not technical property rules. And at home, our expectations are strongest. This case tells police, consent works, but not when someone is right there, standing in their own doorway, saying no. It also tells all of us, living together means sharing space, but it does not mean surrendering your constitutional voice. So if you ever wondered whether no still means no in Fourth Amendment law, in your own home, when you're present, the Supreme Court says, yes, it does. I'm Jamie Carper, and remember, when it comes to consent searches, the front door is not a democracy if someone is home to object.